Hi, I'm Duane Duggan. Welcome to RE/MAX of Boulder's podcast. Today we're going to be talking about a topic called owner financing in today's market. To bring along an expert here, we brought Jon Goodman from Frascona, Joyner, Goodman & Greenstein, a prestigious law firm in the Boulder area. So Jon, welcome. Thank you for being here today.
Thank you, Duane.
So Jon, I've been selling houses for a long time. Back in the 80s when interest rates were really high, we did a lot of owner carry financing. It was all part of our contracts. The world seemed really easy. You just take out your typewriter, type up a note and deed of trust. Things have changed. What has happened that made it not that easy anymore to do?
Well, Duane, I started in the real estate business in the same time, and I did a ton of seller carry financing in that same era. But what changed is the financial crisis that hit in 2008, and different people disagree about what led to the overzealous lending, but most people agree that overzealous lending very much contributed to the financial crisis. So there was a regulatory reaction, and that regulatory reaction was called the Dodd-Frank law.
Okay.
And Dodd-Frank touches seller carry financing. It regulates seller carry financing.
Okay. And back in the 80s, we had a reason for sellers carrying and actually coming to your law firm to do a lot of the note and deed of trust. And that was just the interest rates were so high. So what would be in today's market when the typical lending rate is very good for consumers, what would be the motivation of a seller to want to carry financing on one of their properties that they were selling?
Well, there's a few motivations. One motivation is that as the baby boomers retire, if they sell their properties and receive cash, they put it in certificate of deposits or other more conventional bank investments, they earn a very, very low interest rate. So one reason is because interest rates are so low right now, it's an opportunity for somebody like my parents who own their house free and clear to carry a note secured by a deed of trust. If they get a large down payment, it's a very relatively secure investment, and they might earn 5, 6, 7% at the time we're recording this, as opposed to putting it in a 5-year CD at 1.5%.
Okay.
A second reason that a seller might do it is it might be the only way that they can sell the property. There might be some feature of the property that discourages more institutional lenders from making a loan.
Maybe like condition of the property or something like that.
Condition of the property, the homeowners association might have too many rentals for FHA to make a loan in the property. Those are some of the reasons.
Okay. Now, in the past, there was no limits on like the number of loans that an owner might be able to carry. In other words, if they own 10 properties and they were disposing of their real estate portfolio, they could pretty much just carry the financing on all those. And now there's some rules that dictate the numbers. So why don't we start with the one that's probably most appropriate to most of our listeners is the one-time owner carry financing.
Yes. The idea is that a seller who wants to carry financing wants to fit one of the two exemptions under Dodd-Frank for seller carry financing. And the simplest one to talk about is the one-party exclusion. The one property exclusion.
Right.
What I call the mom and pop exclusion. So that would apply to somebody like my parents. They have to own their house in their own name as human beings. They could own it as a trust, but it doesn't work for entities. It wouldn't work, for example, if my parents own their property in an LLC or a corporation.
Okay.
They can only carry one note in any 12-month period. They can't have built their own home as part of their ordinary course of their business.
Okay, so they can't be a builder.
They can't be a builder. My parents did build their home, but they're not a builder. Okay, and then the third feature of it is the loan has to have two financial features. One is the payments cannot be negatively amortizing.
Okay.
And then the other requirement is that the interest rate on the loan has to be fixed for the first 5 years.
Okay.
The loan can balloon after 5 years, or the interest rate could start going up after 5 years.
Gotcha. Okay, so again, compared to the old days where we might carry a loan for like interest only in 3 years, those days are kind of gone. It's got to be at least the 5 years, and the negative AM means you couldn't have a reduced payment in adding to the principal.
You can't have a payment that's below the amount that's necessary to cover the principal and interest.
Right.
And
right.
Duane, neither one of us are old enough to be able to talk about the old days. It would not be credible to the audience. Okay, but continue.
Well,
yes.
maybe so. All right, so let's talk about that person that maybe has 3 properties, and so that puts them into the investor category rather than owning their own home. What's the difference that somebody that's going to sell off 3 properties and carry financing as far as the terms that they can offer?
Right. Well, one thing to remember is it would apply to anybody who has more than one.
Okay.
Now, if they have more than one, if they have 2 or 12, they can still fit this 3 property
Okay,
exclusion.
gotcha.
They just can't carry any more than 3 loans in any 12-month period.
Oh, okay.
So what? How does this work for them? Well, one thing about it that's more expansive is that this seller can own the property in their own name. They can own it in a trust. But many investors own their rental properties in the name of entities, S corporations,
Right.
LLCs, or corporations, and this exclusion benefits them. The second feature is also true. They cannot have built the property in the ordinary course of their business. There are 3 financial features about the terms of this loan. One of them is that the loan has to be what we call fully amortizing. So it has to have a loan like it has to have a 15-year amortization or 20-year amortization or 30-year amortization. The point of that is it can't be an interest-only loan, and it can't be negatively amortizing. The payments, if the borrower pays the scheduled payments over 30 years, then the loan will be paid off over 30 years. A feature of that, which is undesirable for a lot of investors who want to sell property and carry notes, is the loan cannot have a balloon requirement. Another problem or challenge for investors is that investors have to go through this analysis and determine that the borrower actually has the reasonable ability to pay the loan. That's a direct reaction to the financial crisis, where the perception is loans were being foisted on people because they had good credit, but without any regard of whether they actually had the ability to pay the loan.
So that goes like we've used the example of your parents a couple times. It could be like mom and pop out there that want to carry the financing. So now the law has put a burden on them to analyze whether the borrower's got an ability to repay. That seems like it's difficult for mom and pop to do, if you will. So where do they turn to do that?
Well, remember, this analyzing the ability to repay does not apply to the mom and pop exclusion.
Okay.
It does not apply in the one property in a 12-month period exclusion.
Okay, but
measuring the ability to repay would apply to the Duane Duggan, who has his portfolio of rentals and is selling property and carrying more than one note in a 12-month period.
Okay, so again, even at that level, you have the burden of hiring like a mortgage loan originator or an attorney to create the file to show that you...
Well, thank you for that softball
Yes.
pitch there, Duane. Yes. Yes, I see. Where do they turn to? Yes, well, the self-serving comment is that's one of the things that our law firm does. We have an attorney who also used to be a mortgage broker, and we feel we have a process done that satisfies the seller's need to verify that the borrower has an ability to pay.
Okay. And
Another option is to go to somebody who has a mortgage loan originator's license.
Okay, and not to be too self-serving, but your firm has actually taken the initiative to set up to service these type of financing issues, right?
So yes, service that in the sense of creating the documents, maybe not servicing the payments as they're coming in over the months and years, but yes, set it up.
And as soon as I said the word servicing, I thought of that. So, but that brings another question: if they set it up, then who do they typically turn for servicing, or are they all usually self-serving, if you will?
Well,
self-servicing.
That's an interesting question. I don't perceive there's a market demand to hire people to professionally process the payments.
Gotcha.
If people feel that need, we would be more than happy to take care of that need. But other professionals can too.
Right.
CPAs could take care of that need.
And that could be something as this type of thing evolves, because it is new and the requirements that we have to deal with. It'd be interesting to see how that evolves.
It will be interesting to see how it evolves. And you're right, maybe somebody like my 80-year-old parents would like somebody to handle processing the payments. However, most of the people who are selling more than one in a year are going to be players. They've been landlords, and collecting payments on a note is generally easier than collecting rent payments. When you're a lender, you don't have to worry about it when the dishwasher breaks, when the garbage disposal breaks.
Right. Okay. Well, let's move to Colorado specific. Does that sound good? As far as like when somebody's trying to buy a property, write a contract with their realtor, and use owner financing, what's different today than even just a few years ago relative to the contracting process?
I will answer that question. There's one important thing. There is one important thing, though, that we need to mention is that in the three-property exclusion, the loan cannot have a balloon period.
Okay.
The seller who carries the financing does not have the ability to call the loan due before the 15 or 20-year or 30-year amortization period expires.
Okay.
All right, down to your question. Colorado imposes its own gloss of regulations, and there's two features to that. One feature of it is there are certain disclosure requirements that need to be made to the borrower. They are very much like the truth in lending disclosure requirements that already exist on institutional loans, bank loans. But they're not the kinds of things that people can create on their own easily. And so then the self-serving pitch here is that we have a system for creating these disclosures. The second thing that's different is back in the day when we were really young, even younger than we are now, the state of Colorado's contract had provisions that facilitated real estate brokers and the sellers from completing a contract in a way that addressed the terms of the financing. What's the interest rate? Is there a default interest rate? Is there a late period? What's the amount of the late payment? What are the amounts of the payments? The state of Colorado is concerned that if real estate brokers engage in negotiating those terms, that they would need to have mortgage loan originator licenses. And so the Division of Real Estate has removed all of those provisions from the state-approved contract and has forbade real estate brokers from addressing those issues in the contract.
Okay, and so now within the contract, it just is the amount. So buyers and sellers agree to like the purchase price, the down payment, the owner carry financing, maybe a new first mortgage if they're carrying a second owner carry financing. You can specify that in the contract. But now what does the realtor do as far as a clause for the amount of time to come to agreement as to what the actual terms are?
Right, so you're exactly correct. It is clear that real estate brokers can still write contracts that call for seller carry financing. You can specify one term, and that provision is the amount of the loan. So your question is, how do you get from the contract to the closing when those other issues are not addressed? Right. And the way the state-approved form is set up is it contemplates that the contract is contingent on the parties coming to terms on the financing. So it goes under contract at one point in time. You check a box to indicate whether the buyer or seller has the burden of providing the initial loan terms, the proposed initial loan terms. Let's say it's the seller. The seller is obligated to provide it by a certain date, and then the parties have until a resolution deadline to agree on those terms. If they do agree, the contract lives and moves on to close. If they don't agree, then the contract terminates.
Okay, for a buyer and seller, where do they turn for getting that advice on what terms they might propose? I mean, can the realtor still give them advice and say, well, do it at 6% and 15-year AM? It's my understanding
Right.
The realtor really shouldn't be giving that advice anymore. Is that correct?
The state of Colorado, at the present time that we're filming this, and I don't expect this to change anytime soon, is being very conservative about it. They don't want the real estate broker to suggest terms at all. Even so far as our law firm created a worksheet for real estate brokers that it was very clear it wasn't binding on anybody. It discussed what interest rate meant. It discussed what amortization period meant. It was more informational, and the Division of Real Estate did not like the idea of real estate brokers handing that out to consumers.
Okay.
So some of the sellers are sophisticated enough on their own to propose these things. And if they're not, then sellers and buyers have the alternative to go to people with MLO licenses. mortgage loan originator office licenses. So far, the marketplace hasn't responded to that need with mortgage loan originators. Most people who have mortgage loan originators work for institutional
Right.
lenders.
Making new Fannie Mae loans.
Right, making new loans, and so this competes with that. They will not facilitate this. Maybe somebody will be entrepreneurial and become a seller carry oriented mortgage loan originator. So far that hasn't happened. You may decide you don't have enough education, and you may decide to get an MLO license, and then that would allow you to
give that
write those
advice.
terms. But right now, people are stuck going to lawyers who will help them address those terms.
Okay, sounds perfect. Right, I think, unless you can think of anything else, I think we've covered most of the issues relative to owner financing in today's market. It does seem like it's really evolving, and the interpretation of the new Dodd-Frank rules are going to evolve, and there are some issues that are gray at this point in time, and they'll be tested in the marketplace. So.
Yes, thank you very much for this opportunity.
Right. Thank you, John, for being here. And one thing about this is if you do have some questions that come up, I would love to have John come back to address this and other topics that we could fine-tune some of the things that we present. Duane Duggan, RE/MAX Boulder Podcast.